And if these roles are, if those reasons are not reasonable, then you may have a venues to file for an appeal or motion, whatever it is. But it's a headache which you have to go through unnecessarily. So ensure that. See, lots of that. I'll tell you one thing. Lots of lawyers scare you out for certain situations. I want to tell you one thing. There are certain situations where these things have come out very quickly. Basic thing is, if somebody does identical registrations in the company, in another company, that's where it's coming up. For example, company A registered for 50 applicants, 50 beneficiaries, and the company B also registered for the same 50 beneficiaries, then even though these two companies are not related, but some kind of suspicion is happening. Why it is happening? Why this registration is happening? Maybe as an employer, you may be unaware of. Maybe some guy in India, recruiter may be doing. We have seen these stories also telling me that recruiters in India are doing these lists and everything. But first of all, why are you not checking background of these candidates for whom you're registering? Those issues will come to you to question by the USCIS. So those are the things which we have seen, we have heard, and these problems have been there in processing these cases, And under those circumstances, we have seen that US is coming back and saying that there is a collusion among the employers and these registrations are not valid. Therefore, we'd like to withdraw these H1B petitions or revoke these H1B petitions. We have seen those are the circumstances where they issued the lawyers or other things. But you all have to understand this. USCIS cannot find a fraud under these circumstances. Okay, they actually include the attestation in the registration process for the employer, saying that they are not submitting any duplicate registrations or multiple registrations on behalf of the same individual, trying to game the system and everything. But as per the law or the regulations, there is no ground for them to include that attestations. It is not there in the regulations. And I'm not sure whether they have any authority also to subject any employer for willful fraud or misrepresentation or for any criminal penalties for the violation of that particular attestation made in the registration by the employer. Okay, just want to give you a heads up. It doesn't mean that you are okay to submit multiple registrations, but I just want to tell you that not to worry, not to panic if you have received any lawyers or anything like that in the past for multiple registrations. As an attorney, we should be able to defend in such a way where, as an employer, will not have any liability. Although we may not be able to save the case, that H1B petition, but we'll ensure that we know that we can protect the employer to the maximum extent possible. Of course, there are some employers who are really deliberate. There are too many facts that goes against them to prove their innocence or they prove that they're in compliance with the regulations. But in general, we should be able to address that with a lot of success. And but you have to understand this. Employers cannot submit multiple registrations. At the same time, employers cannot restrict their employees also for them seeking multiple opportunities for multiple employers. I've seen a lot of employers taking an attestations from the employees saying they're not submitting multiple registrations, they're going to only submit from this company and everything. No, that doesn't have any value in the law. Because if he can actually sue you that you were restraining him unnecessarily, unduly by taking up those attestations also. Because employee has a right to work for any employer. He can choose any employer. He can go and work with any employer he would like to. Okay, so as an employee, if he has multiple offers from multiple employers, and if he tends to accept any one of those employers because this job is going to start from October 1, 2023, he can actually pursue H1Bs from all these employers. It's up to the employers whether to file H1B petition for him or not, and it's to the employers for the purpose of filing that H1B petition to submit the registrations on their behalf. Okay, so employee can have multiple offers or multiple prospects from multiple employers and submit the registrations to the USAs accordingly from those companies, as long as those companies have a bona fide job offers by themselves. Okay, so that is very, very important. You have to understand that employees can have multiple registrations submitted by multiple employers, but employer cannot submit multiple registrations on behalf of the same employee for whom they intend to hire an H1B petition. They intend to hire on H1B petition, on H1B visa. Okay, so that is very, very important. Understand the distinction between the both. It's very, very important to understand the distinction between the both. A lot of people don't understand this distinction, and that's where they get into trouble. There's a, it's entirely different. The both are two entirely different situations. Okay, I just want to let you know that information here. And also, as an employer, to protect yourself, when employee is filing multiple registrations, tomorrow let's assume that we heard some cases where they're coming back to the employers also asking that your employee has filed multiple registrations, multiple employers, how that is possible, so he's not eligible. Point is, USCIS cannot ask that question, first of all. Even if they ask, that is easily repeatable. That's the second thing. And point is, let's assume that even that is going to happen, unless you might lose that employer, that H1B. That's the fear you have as an employer. Make sure that you take an email confirmation from the employee saying that he intends to join your company prior to registration. Simple thing is that he intends to join your company, he accepts your offer, he loves you to proceed with the H1B registration on his behalf. Just get an email from him in that way. I mean, I'm just giving the content, but it has to be properly phrased, properly answered. I mean, I'm just giving the content or the summary of the intent, what's supposed to be there in the content of that email, and take that email from him, and you go ahead and submit the registration. No issue at all. For example, I know you know that your employee knows you and your friend's company also, or somebody else in the same street or same building. Other employer is there, he knows them also. You came to know that he's submitting the registration through that company also, although you don't have any official relationship. It's better you take an email from him. At the same time, let that friend also let that company also take an email from him, say that he intends to join them upon approval of H1B petition. Simple thing is that. And it's better to take those emails from your employees so that you're protected while you submit those registrations for the employee. As long as you can show that you have a bona fide need for your business, that's all it is. That's all it matters. Okay, and these are the basic things. These are the things which I want to talk about the H1B cap, Om Garu. Other than that, there's nothing has been changed with the cap registrations, and it's $10 fee this year. We do not know how much it will be next year, but it's anticipated that it will be around $215. But we need to see how much it's going to be as per the final regulations once they pass the final regulations for the fee increase.
Yeah, thank you, Banugaru. And related questions, maybe general question that a lot of people are asking. So one of the, I think the caller, he posted the question: how many we are expecting this year? And the other question is how many offers can be made to a single job from client. So basically, one client can Google a legitimate employer. Can they offer more than one job to the same employee? Yeah.
Not really, though.
How many? Yeah.
Not really, though, because I don't think Google will offer multiple jobs for any employee. In fact, I don't think it's practical also. Okay. They will consider the candidate for one position, and for that position, they will try to make him an offer. And if he doesn't take that offer, why will Google try to hire him for other position at the same time? I don't think it's practical also. So that's basically you're telling that you'll have multiple offers and then you want to file multiple registrations again. You're putting it in a different words, different way in that way. But thing is, employers cannot submit multiple registrations either. Let's assume that Google wanted to hire you for a position of CEO or maybe director of operations, something like that. Tomorrow, Google also intends to hire you for a project manager position instead of a director of operations. Okay, but for the registration, you're not providing any information about what position you're hiring him. For registration, you're submitting a minimal information saying that you intend to hire this individual on H1B petition. That's all it is. So once the case gets selected, once the case gets selected, once your registration gets selected in the lottery, then Google can make a decision whether to hire you in a project manager position or a director of operations positions, right? Because they have both positions available for you. They intend to hire you in either one of them. That can be done at the time. But if it comes to registration, it's only one registration they can submit for the candidate.
Yeah, thank you, Banugaru. Now, the summarized team, you cannot have a multiple petition from same employer, related employer, because last year lots of candidates they got rejections. They did investigate, deep dive into the entire emails, ask them to submit evidence of he has multiple offers. They reached out to each and every employer. So be careful. So as long as it is a bona fide employer, bona fide employment, you can file it. I think for that you need to get a email confirmation, offer letters, acceptance by you, both employer and employee. Please make sure you have the records. Thank you.
Mhm.
If it is a legitimate employer and a legitimate job offer, yes, and completely different employer, not even remote. So but you can apply multiple petitions. Thank you. Banu Garu,
Yes.
one question before we go to the next topic. My question is a lot of H4EAD and GCAD, a lot of people got this and they're starting their own company, they're filing the H1Bs. I don't know whether it is without having the client letter, just using the MSA, you can file a SOW without having SOW, just MSA, will it be okay? Or what about the in-house projects? I see that a lot of, you recently handled one of the or Atmiya, scenario, they filed and VCS started, investigating. So you are representing that that employer. So
Mhm.
can you give a more, maybe 30 or 1 minute overview of what is why you have to be careful when you're filing? Yeah, thank you.
Mhm. See, the issue comes is the USCIS cannot demand any piece of evidence like client letters or for example, let's assume this way. Let's put this way. If you're in a business where you provide IT consulting and services where if it comes to the services part, your employees actually work at the third-party client side. Okay. In general, requirement is that the employee you need to have you usually have some kind of an agreement with them, and that agreement is executed between that client and your company, and accordingly employee goes and work at the third party client side. They physically go to the third party client side and provide the services, but in what position they're providing a service, right? Let's assume that if they're providing services in software developer or some other specialty occupation position. For example, even lawyers also can go and provide services as a contractors to some companies. It happens. Robert F. Legal, all these people, they supply even the lawyers too as a contractors to the big firms to provide services as a lawyers, right? So those things can happen. Any position that qualifies as a specialty occupation, then automatically you're eligible for the H1B petition. However, in the past, what used to happen is under 2010 Neufeld memo, that memo was actually loosely based on Fifth Circuit case, which is Defensa versus Meisner. Okay, and the facts are very different for the case. Now we don't have a time to discuss about all that right now, but as per that memo, what the USCIS is to demand is that you show that you are actually controlling the work of the beneficiary at the third party client side, because the person is working at the third party client side. You don't know exactly what is he doing over there. You are telling me that he's going to work as a software developer, but we don't know he's working as a software developer or not, right? So in order for you to prove that he's working as a software developer, you need to provide a client letters or a client agreements or some other documents to show that he's actually in fact providing services as a software developer. And also is working as a software developer for the entire duration of H1B petition. Because in the past, what happened is people file an H1B petitions and suddenly these people won't work. I mean, they don't have a job for this individual. They don't pay him. They keep him on a bench, and there were a lot of mistreatments happen, and also a lot of people misuse this H1B program. Like for example, some people I know, they file H1B petitions for the restaurant workers saying that they're working as a software developers, but actually they're working in the restaurants and as a servers, as a waiters, as a cooks and chefs. And these things happened in the past with the H1B program. These violations have happened with the H1B program. To avoid all this unnecessary fraud, they felt like this is the right situation to do, but they've done it. But they basically went to the common law definition, which is what actually said by the Defense versus Meisner, common law test, who controls the employment, they are the ones actual employers, right? So they wanted to prove that you actually control the work of the individual and individual actually working in a specialty occupation. That Neufeld memo is basically is in all the way around. It is against the regulations. It's against the statute of INA and against the H1B regulations. Nothing has been stated because the common law definition will come into existence only when the regulations or the statute does not define what constitutes a specialty occupation is. Okay, and what constitutes an employer-employee relationship is. Here,
Yeah.
the regulations and the statute clearly define, if it comes to H1B purposes, what constitutes an employer-employee relationship, what constitutes a specialty occupation is. That's why that Neufeld memo was outrightly wrong. They can't implement by policy memo. They can't change the entire law by policy memo. And that's what the USS did. And they actually successfully implemented that for 10 years without any objections, without any fight. And we were fighting with them. In every case, we used to make an argument saying that they don't have any authority to do that. But nothing much can be done. They will keep on forcing on it, pay on the people, and people are going on it. And obviously, IT surveillance came in front in 2018 and filed this lawsuit. And the decision came in 2020 saying that this memo is actually not valid anymore, right? And therefore, USAS cannot demand any client letters, client agreements, or anything like that. As long as employer can establish this a valid employer-employee relationship, and based upon the nature of the business, if they can show that they have a bona fide job offer in a pro-offer specialty occupation, what I mean to say pro-offer specialty occupation, it means any position in which they intend to hire, like a software developer or a software engineer or a project manager or software or systems administrator or network administrator, whatever position they wanted to hire them, then if they can establish that under the preponderance of the evidence standards with the minimal information, then they cannot be denied H1B petition. They have to be approved. And also, in 2020, court clearly said that they can't even demand itinerary for the individual because the statute clearly allows legal benching. That means as long as the employee gets paid while they're on the legal bench by the employer, it is absolutely okay. When is legal benching usually happens? When the employee is in transition between one project to the other project. Okay, and that is the reason. That's what has happened. And if one, then legal benching is absolutely allowed. So, but we are seeing still USCIS one way or other indirectly they're trying to implement this Neufeld memo by the site visits or some other issues and everything. And we need to keep on fighting on that. So if it comes to UMGAR, what you asked me is that if these new companies, can they file H1B petitions without any client letters or anything like that? The whole problem comes for them is how do they show the nature of their business and what they have done in the past, right? For example, if they're in established companies, they can show that based upon the nature of their business, they have a need for these specialty occupation workers like software developer, software engineer, and all these people. If it's a startup company, and especially when their employees work at the third-party client side, how are they going to show that they have any need for this specialty occupation worker? They just can't file an H1B person to keep them on the bench, right? You just can't accumulate people and keep them in the bench, and then you market them, and you cannot monetize or benefit with it legally. Statute, although statute provides legal benching, but statute also does not provide any provision stating that you can actually gather people, keep them here for you to monetize the benefit. If that is the case, everybody can gather people, keep them in, and then they can monetize them, right? H1B program cannot be used for the purpose of importing people from foreign countries to the US for you to benefit monetarily. So that is the problem you will have when you have a startup company. How are you going to show it when you don't have a client letters or anything like that? How we are going to show it? So it's important that you having some kind of a business arrangement with your clients, especially when the employee works on the third-party client side. Although you're not required to provide those documents, but having those arrangements is a good idea. And filing H1B petition based upon that is a good idea. And
Thank you,
some
Banu
clients,
garu. Yeah, sorry. Continue. We have a lot of questions on the topics.
yeah. One more point I want to tell, sir, because before, if I don't tell that, it will lose the context of it. Okay. And other thing is this, in-house projects, right? If you have an in-house project, if you're really seriously developing an in-house project, even if you're a startup company, you can do that. If you can show that you have a financial wherewithal to develop those projects, and you're actually going to develop those projects, you're going to work on them, and you have all the infrastructure for executing that project, and that project, in fact, requires such a high-paid worker, right? That means it's so complex in nature that you need somebody with such highly specialized knowledge. That's what the specialty occupation is all about, right? Individual with highly specialized knowledge. And the position requires at a minimum master's degree or its equivalent in a specific field of endeavor in which he intends to work for, right? So when you can afford that kind of individuals, if you can show that you have a financial wherewithal and you have infrastructure to develop those projects, you can actually file H1B petitions for them. And tomorrow, after once they start your company and everything, after 2-3 months, if things change, and if you can document those circumstances changing, and if you send them to a third-party client, it is absolutely okay. And those situations, I'm ready to fight any level with the USCIS as an attorney. As long as we can document that there was a bona fide in-house project in your company. You just can't create a documentation showing that I have an in-house project and file an H1B, because you're actually creating a vehicle and you're trying to do that. But of course, the issue comes is there are a lot of things will come. The thinking is that whether you are intending to cheat the government by saying that you have in-house project, where you never intended them to use for the in-house project. If they can prove that against you, then you'll be in trouble. And they can prove that with the circumstantial evidence. Okay, so those are the things which we have to really look into that. But as I said, you don't have to provide any client information or anything like that filing an H1B petition. You can file an H1B petition with blanket, but only thing is you have to state the work location where the beneficiary works in the LCA as well as in the form I-129 for the H1B petition. As long as you're able to sort those out and everything is there, we can file an H1B petition establishing your nature of business and showing how your business is going to grow in the future, what kind of a nature of agreements you have, what you have, and everything. We should be able to do that, because you don't have to provide the client letters and everything. But it's on a case-by-case basis only.
Yes. Yeah. Thank you, Banu garu. One last final on that to conclude on the topic. How many are expecting, Banu garu? For last year, 4 lakhs.
I'm expecting at least 500 to 550,000 this year, minimum.
Thank you. Thank you. Last year, Rusa, do you remember how much is that?
480,000, approximately 480,000.
Almost 70,000 more. Okay. Thank you. Next one. Sir, we can ask to secure letter, sir. Please, we are already 30 minutes. We have other topics. Definitely, please pause and I will take your question. Banu garu will take the question. Banu garu and 221G, we have the WhatsApp group, so many questions back and forth. What do you think about 221G? There is a refused, rejected, or no response. So what is the refused means? What is the rejected means? What happened to the no response? How long we have to wait? When we can approach the attorney? What we can do? Thank you, sir. Can you answer it?
It's always better to approach attorney even before going for the stamping. Discuss with the attorney what the situation is and everything, and accordingly submit the documentation to the consulate in India. And the other thing is, lots of 221Gs are coming. So rejection or refusal is nothing but it's somewhat same only. Okay, 221G means it's actually rejection or a refusal of a visa. Irrespective, they issue that asking you to submit the further documents and everything. In legally, if they issue 221G for you, that means your visa application has been refused or rejected. Okay, just keep that in mind. And when they ask you to submit the further documentation, once you submit the further documentation, and you have to make sure that what they're asking is reasonable or not also, whether legally it's allowed or not also. If it is not legally required, and if they're demanding some additional information that is not required for them to adjudicate their visa application, then it's our responsibility to let the consulate know that this information is not required by the statute. And as per the statute, we already met the requirements with the documents which we already submitted to the USCIS. It's so we submitted to the USCIS, and the Department of State has to comply with it, has to adhere to the standards. They cannot create their own separate standards. It's important for us to let them know that. And if you do that, sometimes the cases gets adjudicated fast by the 221Gs. We have seen recently a lot of cases whenever they issue the 221G asking for the client letter or client agreement or anything like that. When we responded to them very strongly, explaining them what the regulations are and everything, we've seen them approving those cases. Okay, and many of the 221Gs are being given, especially when they have any doubts on the documents that are submitted by these individuals when they go for the stamping. For example, if they go for the stamping, if they submit any client letter or any client agreement or a purchase order, and if they have any doubt whether those documents were genuine or not, those are the circumstances we have seen them issuing 221Gs, and they say them that it's held in abeyance for the administrative processing or no response. That's where you see this no response and everything, because they have to conclude the background check verification for that, like site visits, compliance, everything, site visit verification, try to gather the information from the client, from the vendors or the employer, whichever party is involved in between. And that will take a time for them because that information has to come from the USCIS again to them. And that's where you will see the cases taking a long period of time, or they won't mention anything saying that what documents are needed, but they say that just pending review or pending adjudication review, and they give you these 221Gs. Okay, and so those are the situations where we are seeing a lot of 221Gs, and lots of site visits also happened in 2023, 2022, and 2023 happening now, is because of the lots of cases were referred by the Department of State to verify whether the companies have a bona fide requirement for these individuals or not. And we have seen RFIs coming in these circumstances asking that you don't have a requirement, so we would like to find a fraud on the employer. And as I said, they just can't find a fraud on their whims. They have to have proof. Anytime when they want to find anything criminal sanctions, they have to have a proof beyond reasonable doubt that employer did in fact committed a willful criminal fraud or misrepresentation. So don't get panicked when you receive any NOIR or a NOID saying that we found a fraud under the circumstances or anything, the circumstances which I described before. Reach out to us. We are very happy to help, very happy to work on them. We are very confident that we can get those things done based upon the recent decision given in the 9th Circuit also. If the statements made by you were not material for the USCIS to make a decision whether to approve the case or not, then those statements are irrelevant. Even those statements are false. Okay, so my whole issue is as an employer, you are not required to provide any itinerary. That means you're not required to provide any nose project documentation or any client letters or client agreements or anything like that. Even if you provide, USCIS should not consider that evidence because by regulations, those documents are not required to make a decision on your case. Because they're not required, if the USCIS says that because of these documents you committed a fraud, that cannot stand in the court of law. That's what happened in 9th Circuit in recently, and we are very confident about that. We have made so many cases arguments in that way. In the NOIR cases which we received recently, we have successfully able to withdraw those NOIRs and able to reaffirm those cases and those approvals for those employees. Okay, and we have to keep on fighting. I mean, if it comes to the 221Gs, we have to keep on fighting with the consulates. We have to keep on fighting with the Department of State. We have to file lawsuits against them. If you don't file lawsuits, if you don't get the results from them, this is the whole problem is it's about the policy issues with the Department of State. They are implementing new full memo, irrespective of what the courts told them, what the USCIS told them, even by USCIS actually repudiating the regulations passed in accordance with new full memo also. Still, the Department of State is trying to implement that. That's why they're asking for the client letters and client agreements and everything. And I strongly believe, I think I said this in the previous call also about our conversation, my in-person one-on-one conversation with the then Consulate General of Hyderabad. That means now she's a Consulate General of Hyderabad uh, about this 221Gs issued for the client letters and client agreements in Hyderabad Consulate. And she clearly admitted that it's completely a policy error by the Department of State or it's a training issue. And they will work on that. They will try to sort out that issue. That's why we are seeing some decent number of approvals from the Hyderabad Consulate compared with other consulates. And probably because they're trying to implement those changes slowly. It will take some time for them because it's a lot of training issue for these employees. We have seen this problem even at the Customs and Border Protection also. Some employers, some officers there also, especially in the airports like Abu Dhabi and Chicago, they're demanding for these things. They're not willing to compromise, probably because they are still that whatever you call them, they have that bias or prejudice, whatever it is, but they still believe that that's what it is. They're trying to implement that law over there because they have an authority, because you don't have a right to due process at the port of entries. That's why. They can do whatever they want to do, but you have to fight on it. You should not sign on any document when anything happens like that at the port of entry. Tell them that you decline to sign any document. When you decline to sign any document, they have no force, but they have to give you those documents and send you back. When they send you back, you can fight against them. Then we attorneys can come in and fight against them internally by filing a complaint with them, saying that they're actually practicing not a legal not a proper practices over there. But if you sign a document, then you're admitting, you're confessing. Very little we can do on that.
Thank you, Bhanu garu.
Yeah.
221G, any questions we can answer it. I think Bhanu garu, how they can reach out to you if they want to represent you.
Yeah, they can always reach. So they can always reach my office number 703-496-7722 during office hours. That is Monday to Friday, 9 a.m. to 6 p.m. to set up time and talk to us. Or they can always reach me on my mobile also, which is 319-400-0053. So if I don't answer mistakenly your call, because if I don't know the number, sometimes I don't answer because I get so many calls. You just have to text me saying that this is X from Atmiya. That's all I need to know, sir. Okay. And if I know that, or if they can tell your name as a referral or somebody else's name as a referral, whom I know, or they can actually tell Atmiya, that's more than enough. Immediately I'll make sure that I will talk to them. So
And can you please repeat the number, please?
It's my office number is 703-496-7722. My mobile number is 319-400-0053.
Thank you.
Yeah, thank you. Thank you, Bhanu garu. The next one is the GC bulletin. It's disappointing for a lot of people to address. And what is the Child Care Protection Act, sir? And briefly, can you cover, please? We have a lot of questions.
Yeah, sure, sir. See, I mean, I don't want to give any false hope about the retrogression or the dates moving forward for the immigrant visas. It's going to take some time again. I mean, I don't think we're going to see the movement aggressively for this year at least. Okay, I just want to give a heads up on that. If it comes,
it's really disappointing. Yeah,
I
don't
know,
you think
I know,
you
sir.
have some kind of hope because family base is retro and maybe spill over to existing petitions are there. This year quota family base will be spill out to this year and no hope.
Yeah, unfortunately, no, sir. I mean, I'm being very honest with you because consulates are working fully right now abroad. I think they're coming to the full strength of the staff and everything. And in 2022, they had a very few numbers available that have been assigned to the employment-based category in fiscal year 2023. And I don't think it will be any different for the fiscal year 2024 with the number of family-based petitions being adjudicated abroad for the fiscal year 2023. So I'm being very honest with you. I mean, the moment will be very slow for the immigrant visas, at least for the next couple of years. That is for sure. And if it, so I would like to move on to the next topic, sir, which is Child Status Protection Act. And that's great news. That's amazing news by the USCIS, and we are very happy that USCIS came in public and actually explained about that policy. Because, to be honest with you, we are seeing a lot of adjudications even prior to the USCIS announcement adhering to that policy in approving the green cards, adjustment of status applications for these minors who actually became 21 years, and they did in fact file their I-485 based upon the filing dates rather than the final action dates. Okay, and them being aged out, being more than 21 years of age at the time they got their adjustment of status applications. And we knew that USCIS has been very silent on this. They did not make any noises, anything. In my office in 2020 fiscal year, when the visa numbers are opened in November, December, January, we filed almost 650 adjustment of status applications in those 2-3 months. And we have a lot of minors in them. Like we might have probably around 40 to 100 people, actually 40 families, I believe we have minors who are aging out in that. And that means we had around more than 40 to 60 kids who are aging out, basically, for whom we filed. Not a single kid adjustment of status has been denied. And many of the 650, probably around 450 cases have been approved for us. Only 200 to 225 people are the ones who have not been approved because the priority dates have been retrogressed and those cases have been pending. But we got a lot of approvals in the year of 2021 and 2022 for these cases, when the dates were current. And all these kids, who were aged out, we were worried. We are telling the employers, to the father parents, not to expect too much on this. Let's hope that everything good happens to them and everything. And all these kids have got their adjustment of status applications approved, and other kids, some of the kids, they went for the interviews also, and the interviews went very well. They did not do that. So we knew that something is going on inside. They're going to issue some kind of a policy that is going to benefit everyone. And it's a common sense policy change. Very important to understand it's a common sense policy change. Why it's a common sense policy change is when in 2003, when the Child Status Protection Act has been passed by the Congress, in visa bulletin, there is no filing chart. Department of State used to issue only final action dates in 2003 in the visa bulletin. They never there was no filing chart available at the time. So Congress would not have even been envisioned the Department of State will actually implement this kind of a policy change and this kind of a regulatory change and start including the filing chart for these individuals in 2003. So Congress' intention was to actually provide a protection for these children who are aging out. That was their intention in passing the Child Status Protection Act. That's what the Congress intent when they actually passed the Child Status Protection Act. It's not technicality. Technicality, if you go to the technicality, then obviously we'll have a lot of issues with this Child Status Protection Act. But this is what it is. It's a common sense regulation. Because there was no filing chart available, because the post after passing the statute, and there was no other statute has been passed, this in 2011 Department of State, without thinking how this child status protection, how these children will be affected, they just included the filing chart just to convene people to file their adjustment of status applications based upon the filing chart, although their final action dates are not current, because these individuals can get their green cards. And that is also because of the huge backlog with the immigrant visa petitions pending. And this happened during the Obama administration in 2011, right before the 2012 elections. That's when Obama administration actually did something for the immigration. And this is one of them, which they have implemented at the time, saying that individuals can file their adjustment of status based upon the filing charts dates rather than the final action dates, because thousands and hundreds of thousands of people are waiting in the line to file adjustment of status applications at that time. And that's why it's a common sense policy change by the USCIS. They came and said that right now is Child Status Protection Act will be applicable for the individuals, for the children who file their applications, adjustment of status applications, pursuant to filing chart, and they aged out while that application is pending. Okay, that is very, very important because CSPA works very differently, right? CSPA doesn't give you protection straight away like that, because you file adjustment of status application, and if you cross 21, you are not automatically protected under CSPA. It calculates the age. It's called CSPA age. Whether at the time of adjudication of your adjustment of application, whether your CSPA age is 21 or not. That's what they look into. So there's a very complex math calculation is involved here, and as long as that math is meets, it's very easy. It's complex math one way, but for us it's very simple, because as Indians we are very good with math. It's very simple for us. Math is this: what is your age at the time of filing adjustment of status application? And from that time, they're going to calculate the number of months the case has been pending with the USCIS for processing of your 485 application. And at the time you actually adjudicate, if you cross your 21, at the time of adjudication, from your actual age, they're going to deduct those processing time and then see whether you're still 21 years of age or not. If you're still considered 21 years of age or not at the time of adjudication because of that subtraction, and if that happens, then you'll be eligible for getting the green card. That's what the CSPA is. And it's a great thing that this common sense regulation has been passed by the USCIS. It's actually helped thousands of children. I mean, I would say hundreds of thousands of children. Not hundreds, thousands of children who are in this situation. For them, honestly speaking, they don't know any other country. Although they were not born here, they came into this country when they were kids. They did their schooling here. They grew up here. They did their college here. And everything is here for them. It's not fair to tell them that because you're 21 years of age, you just leave and go to some country which you are not even aware of. What is there in it? They can't even speak that language. They can't even understand that culture. So it's
Thank you, Banagar. It's very good, right policy memo from UCS after a long time.
Yes, it's a very good policy by the USCIS. That's why we have to appreciate when the US has done a good thing, and at the same time, when the US is trying to do something not correct legally, then we have to fight. We have to object to it. We have to fight for it.
Yeah, and coming last one, Banagar, in the agenda. Then you can go to Q&A. Multiple, stamping inside the United States for the renewals at this one. What is the stand? I hear that it is going to implement from the September. Any idea?
Very likely, sir. It's very likely going to happen from September 2023. And I'm very happy that Department of State really thinking about it, because it was there before. Until anthrax happened in 2003, it was there. People who were in the US were able to renew their H1B visas in this country, renew their any visa, L1 visa, H1B visa, while they were in the US. They do not have to travel to renew their visa. That's called automatic validation. And that's what they used to do it at the time. In 2003, when the anthrax happened, because of the security reasons and everything, they actually shut down at that time. And when they shut it down, they actually removed the entire unit, and they stopped processing H1B visas or any other visas locally here. Now again, because of the delay, adjudicating delays happening and the workload they have in all these consulates in abroad, they intend to open up this program. Now they're calling it as a pilot program, because it's entirely new system, new regulations, new implementations right now. That's why they're calling it as a pilot program, which is going to be a temporary implementation in the beginning as per them, but eventually it's going to become permanent, because if there are any glitches in the system or any errors in the system, they're going to correct that. We have to appreciate that, and it's very likely to happen because Department of State is very serious on this, and they're very eager to this. They're very excited to implement this one, and the current government, the current administration is very excited to do this, and I'm very likely that from September 2023, it's maybe a month here and there, but it's going to happen in 2023. I'm very positive about that.
Yeah. Thank you, Banagaru. Now we'll go to the Q&A. First, Ram, please wait. There is some questions entered by the audience. When you submit the form. Mahesh Muchala, are you there? Mahesh Muchala. You are in the call.
Yes, I am there. Andy.
Yeah, Mahesh garu, can you ask the question?
Yeah, my
Mahesh
question.
garu. Yeah.
My question was regarding H1B, Andy. There are multiple questions actually, same for regarding extension. So while H1B extension is in progress with employer A, can we process the transfer with another employer?
Answer is yes, you can process. But the thing you have to understand is, at the time of filing for a transfer, do you have a valid I-94? That means, see, when you file for an extension with employer A, you can still continue to work up to 240 days, even after expiration of your I-94. So at the time of filing a transfer, whether your I-94 from the previous H1B has been expired or it's still valid. If it is expired, then sometimes what happens is USAs will say that this extension petition is actually acts as a bridge petition. That means if the extension can be approved, then we can approve the transfer with extension of stay to the employer B. Otherwise, what they will say that they'll approve the transfer, but they will deny the extension of stay and require the individual to go abroad and get a visa stamping and then come back. But there is no restriction saying that you cannot file for a transfer while the extension is pending.
Okay, that's what I'm looking for. So in that case, once the transfer is once the extension is completed, only then it's better to go for transfer, right, Kadande?
I mean, if your I-94 is expired, if your
Yeah,
I-94 is not expired, then you can file it anytime.
Okay. Then in that case, I have filed H4 and H4 EAD also separately from H1 extension. So once I transfer to the new employer, do we need to file H4 EAD also separately again, Andy?
It all depends upon, right? If you file for a transfer and you move to a new employer, if your current employer withdraws the H1B petition, then automatically that H4 and H4 EAD will be denied because they do not have any proof that that H1B employee is actually maintaining valid status, because H4 status is dependent upon H1B employee maintaining valid status in this country, right? So in that circumstances, it's a good idea to file H1, H4, and H4 EAD again, assuming that you're going to move forward because your I-94 is still valid. You want to move to a new company. There's nothing wrong in filing it, provided because you know that when their I-94 is also expiring along with you. Okay.
Okay.
Thank you, Banu garu.
Thanks.
Yeah.
Thank you. Next one is Banu Prakash Sata. Banu. Oh, he's want to apply for India. That's fine. Ignore. I will, Banu, I can answer your question. Please ping me offline. 209-360-6918. Or ping the Atmiya immigration group. 209-360-6918.
Yeah.
Now, EB2, Kranti Kadiri. Kranti, are you there? Kranti is posting messages. Okay. Banu garu, challenge is his L1 got maxed out and H1 is not picked up in the lottery. His son is a kid is a Indian American citizen. What is the way to come back? I'm sorry. The question is, some people are filing 9 petitions. Can we file? I think you answered the question. Kranti garu, I can answer it. Let's discuss offline. Yes, these are very unfortunate. Your son is citizen. That not much you can do. Your son after 18 years old. Yeah.
How old is his son, sir?
4 years. No.
Yeah.
In 4 years he's trying. He's not lucky. Hello,
Yeah.
Kranti garu?
Yeah, I'm here. Yes.
Kranti garu is not there. Kranti, are you there? Okay. Banu garu will go back to the Kranti come back. I will ask him.
Okay.
Deepak possibility, yes, it is answered by the can I file multiple petitions as long as it is a legitimate employer, bona fide employment. You can file it Deepak Sai possibility. And Srikant Palala, Sri Pranidhi Palala.
Can you repeat that, Andy? Om garu?
Deepak Sai.
Neneనండి. Yeah, I am.
Deepak, you can file multiple petitions at different employers, not related employers, you can file it.
Okay, thank you.
చెప్పాం కదా చేసినప్పుడు రేపు మీ మీద కూడా వస్తారు. Say that అది లాయర్ గారు you have to have a employment offer letter from each employer.
Okay.
You should reply back that I want to join that employer. Okay, once petition is picked up and everything. Okay.
Okay. Sure.
Yeah, thank you. Next one is Sri Pranati Pallala. Pranati, we answered. You don't need to H4EAD. You don't need to go to H4. You can continue to F1 status. Okay. Next to Ram Garu, please. You can ask Manu Garu question. Ram, raise the
Hi,
hand.
can you hear me, Andy?
Yeah, I can hear
Yes,
you.
Manu Garu.
Yeah.
Ram Garu, you can ask.
Good evening, Bhanu Garu, and thank you, Bhanu Garu and Atmiya team, for your time and facilitating this session. My question is around 221G, Andy. So, got it to 221G in October. Regarding they're not convinced about the project and location, so they gave 221G and asked for documentation. We submitted all the documentation, and when we checked the status on the email, they said we will respond or contact if needed, but there's no further communication. And so do we have to wait? If we have to wait, how long we have to, or can we counter it? Second part to this question, and if you don't mind, we're actually looking to see if we can apply for H1B transfer and go for a new visa. So will that be a better option, and how to do it the right way?
Let me talk the first one, sir, and then we'll talk the second one. Okay.
Sure, Andy.
The first one, see, as I told you, they can take as long as they want to take time to complete the background review. That's what they will tell. It's a background review, right? You submitted the documents to them. Now they're going to review those documents. They're going to verify whether those documents are genuine or not, because these documents were not submitted to the USCIS. That's why.
Okay.
And they're going to verify. They say that they will be verifying them. Probably they will request it. They would have requested already the FDNS office to conduct the site verification and see whether these documents were genuine or not. Okay. And sometimes that can take time. We don't know how much time it will take. And that's why we don't hear anything from them. And they don't tell us exactly what's going on inside also. If you want to file a lawsuit, yes, you can file a lawsuit on the situation. That is only the other option. But my point is, irrespective of whatever the result they're giving you, every week keep on sending an email to them. Every week keep on sending an email to them. Okay. And that's only the way you should keep on being earing against them and everything. And that's all I can say under the situation, as I told you, right? Because you don't have a right to due process at the consulates,
Right. Yeah.
And if it comes to the second part, that is up to you whether you want to choose another employer and go for a visa stamping again. And if you want to do that, most likely you may have to withdraw this petition, this visa application. And then again, you have to apply DS-160 for the new application, new petition for the new employer, and provide the reasons why this visa was not issued to them. And if that happens, if they still believe that that information is genuine and bona fide with that company, they may issue the visa. But that is the option which you can always think about it. Don't be hasty, but if it's a really good opportunity for you from that company, then you should take that opportunity.
Okay, but is this 221G going to be a black mark on the candidate, and if we go for another visa through another company?
221G is nothing but a refusal of a visa or a rejection of a visa, right?
Yes.
That means in DS-160, if they mention, have you ever been denied a visa, you should say yes to that. Hello.
It's not a really black market. It's different reasons they can deny it, so they can refuse it. It's okay. Okay, you can move on. Okay.
Okay, Bhanu Garu, thank you for your response, Andy.
Thank you,
I
Ram
will
Garu.
contact
Please join
your
the
office, Bhanu Garu. Thank you for your time.
Sure, Andy, definitely.
Ram Garu, please join Atmiya group and Atmiya take Atmiya membership also. Thank you. Next, Ratnashri Garu.
Thank you, and
That's
thank you
Madhukar.
for taking my question. Thanks, Banu Garu. So I have two questions. The first one is there any form for an employer to submit withdrawal of H1 after moving that employee to another company? So how that works?
Just a simple cover letter
To
from the employer.
From the employer to ASCS?
Yes, with the case details and everything, simple cover letter saying that the employer is no longer working, therefore we would like to withdraw this H1B petition.
There is no form, right? So just letter.
Just the cover letter along, that's it. Usually we send the cover letter and the H1B approval notice, copy of the H1B approval notice to the USCIS.
So if we don't do that, is there any reward?
It all depends upon if the employee, see the point here is this, the proper termination of H1B employment requires you to properly notify the employee of the end date of the employment, and you have to properly send for the revocation of the H1B petition to the USCIS. And if you don't, then it's not a proper termination of employment as per the H1B regulations and the Department of Labor regulations.
Okay.
And if it's not a proper termination of an employment, then the employee can come back and demand back wages from you.
Oh, okay.
Okay, and that's what it is. But if the employee resigns, even sometimes the employee can come back and say that he can demand back wages, but at least you will be protected from the Department of Labor. In practice, I've seen Department of Labor considering these resignation letters properly, even if you did not timely revoke the H1B petition, and not subjecting the employers liable for the back wages for the period which the employee is demanding, ex-employee is demanding. Okay, but employees, how can you trust your employees? I mean, if they're getting free money, why will they leave you? Why will they take advantage of that? And everybody will try to take advantage of free money.
Correct.
So it's better for you to be in compliance. I think it's better for you to revoke that H1B petition because it's a purely employer-employee relationship. There cannot be any favors here.
Okay.
Yeah,
So-
Dr. Silgar, I can give the sample.
Yeah.
letter.
So another one is like I got 221G for one of my H1B candidate around after 16 months, he got approval.
Very good.
So no clue why they took that much long time. I have no idea. And they put the tick mark for all the boxes for the first 221G. And luckily after 16 months, they approved. We haven't followed anything. We just sent like maybe around 4 or 5 emails every 6 months. Other than that, we didn't do anything.
That's great. That's great, right? At least after 6 months, they approved it. That is great.
Yeah.
You know.
So another employee also got the 221G. They just tick mark only administrative process, nothing else.
Yeah.
And it's
That is
almost 4 months.
That is the one you should litigate.
Okay. So when I talked to one of the lawyers, they said like, no need to go for another lawyer, just continue with the same lawyer and send an email. Is the best approach or better to go for another lawyer?
No, you should file a case against the Department of State because administrative processing means they can take as much time as they want to take. There are so many cases in the before when the Department of State said that we have a background check pending, we can't adjudicate this case, courts side them. But if you look into the 221G regulations, it doesn't allow the US Department of State to issue 221G saying that case is pending for administrative processing. They cannot state that in the writing. That's why you should file a lawsuit for that reason, because they actually in violation of the regulations by stating on that one saying they're administrative processing. Okay, because they cannot say that. I mean, in regulations, never been said that. I think this is the new thing. I mean, no lawyer explored this option till now, but I would love to explore this option, filing a lawsuit against the Department of State if any client is willing to take that risk.
Okay. And in the second case, I came to know they sent a letter to the employee, the client, where I provided some documentation. And client replied within a week, yes, I need this candidate. And even though there is no change in the case.
Sometimes it will take time for them, as I told you. I think I've given this example, exactly the same or similar example in my initial monologue about the situation, about the 221Gs, and this is what we said. Sometimes they can take time on that because we do not know exactly how many cases have been pending with that officer, where the file is piled up in the office. There could be several factors for that.
Okay. Yeah, I approached the same case with one of the lawyer from IT firm, and maybe we can talk later when you have 10 minutes. I don't want to
Sure.
prolong everyone. Thank you so
Hi,
much.
Banu garu. Regarding lawsuit, will there be an impact to the candidate, Andy?
No,
If
not
we
at all.
file-
Andy. Not at all, Andy. Not at
Okay.
all.
Like
Not
they
at all.
won't they take it against him in the future interviews
No,
or anything?
not at all, sir. Why will they have anything personally against you? You're trying to
Okay.
exercise your right, and they're trying to defend their situation. There's nothing personal here.
Okay, got it, Andy. Thanks, Andy.
Thank you.
Next to Malleshwar garu, it is very valid question. GC Child Age Protection Act. Malleshwar garu, please. Banu
Thanks.
garu.
Thanks, Om Garu. Thanks, Atmiya Group. And thanks, Banu Garu, for your time and considering my question, honoring at this time. Yeah. Banu Garu, just a question regarding the Child Protection Act, right? I got my green card 9 months ago, and my daughter was aged out at the time. And when I applied, my prior it was 2013. At the time, she was not aged out. She was at my 140 was also approved around 2014. She was at 15 years. So can I apply as a Child Protection Act? Can I apply for?
Haven't you filed adjustment of status for her along with you, sir?
I haven't done yet that time because she was aged out, right? At 140, because
she was aged out at the time you filed your 485. My question is that.
Yeah, at the age of 485, she was aged out.
Okay, by calculating CSP at the time, for how many days your I-140 has been pending, has been processed, have you deducted that at the time you're filing your 485 at 21 years of age?
No, sir, I haven't done that.
Yeah, that is a problem right now. I
Okay.
think now, I don't think now she'll be eligible to file adjustment of status application. It's 9 months right now. How many months your I-140 was pending at that time? I mean, at the time of adjudication.
My I-145 almost pending around.
Not 485, sir. I-140. Your I-140. We cannot count your I-485. We can only count your I-140. How many months your I-140 processing took time when they initially approved your I-140?
I think it is close to around 9 months, sir.
Okay. When did she aged out? When did she become 21?
She aged out around 2019.
Yeah, but she doesn't have enough CSP age to file 485 right now, sir, unfortunately.
Okay, thank you. Then she has to go the same process as I'm going through. Okay.
Yeah, unfortunately, yeah.
Thank you, sir. Thank you very much. Yeah, thanks so much.
Yeah. Veerasai Gopa.
హాయ్ భాను గారు సాయి అండి ఇక్కడ ఎలా ఉన్నారు బాగున్నారు ఇక్కడ ఏంటంటే ఒక కేసు ఉందండి వైఫ్ అండ్ హస్బెండ్ ఉన్నారు హస్బెండ్ ఇక్కడ అవుట్ ఆఫ్ 6 years లో 5 years 3 months ఉండి వెళ్ళిపోయారు ఓకే ఆయనకి 9 months ఉంది ఇంకా ఓకే H1 ఇంకా 9 months ఉంది ఇప్పుడు ఆయన వైఫ్ కి H1 వచ్చింది ఇప్పుడు H1 పిక్ అయింది వాళ్ళు స్టాంపింగ్ వెళ్తున్నారు ఇప్పుడు సో ఇప్పుడు ఆయనకి ఇప్పుడు ఎట్లాగా ఆయనకి H4 మీద రావడం బెటర్ అంటారా లేకపోతే అగైన్ H1 లాటరీలో వేయడం బెటర్ అంటారా
he can try both అండి there's nothing wrong with it కదా ఓకే
అంటే ఆయన 9 months ఉంది 9 months ఉంటే మరి ఇప్పుడు 9 months లో వచ్చారనుకోండి వస్తే ఇప్పుడు ఆయనకి ఎట్లాగా అంటే
H4 కి ఆ రిస్ట్రిక్షన్ ఏం లేదు కదండి
H4 రిస్ట్రిక్షన్ లేదు బట్ ఏంటంటే ఆయన he wants to come on H1B
if he wants to come on H1B
he's having only 9 months of period okay gap.
Yeah, he doesn't have any I-140 filed for him, right?
No.
Yeah, then it's better for him to get selected in the lottery and come back on H1B through the lottery only. Obviously, you'll only be able to be in 9 months. In 9 months, I don't think any employer can process the labor certification successfully and get I-140 approved by the time for him to seek an extension beyond 6 years. You know?
భానుగారు దాని బదులు భానుగారు నాకు తెలిసింది ఏంటంటే ఐబీకి ఆల్రెడీ H1 ఉంది 9 months ఉంది కదా అంటే నేను చేసేవాడిని ఇంతకుముందు ఏం చేసేవాడిని అంటే ఆ అబ్బాయికి ఇప్పుడు ఇమీడియట్ గా పెరం ఫైల్ చేసి H1 మీద
అదే సార్ ఇవాళ రేపు పర్మ్ ఇప్పుడు let's assume that you initiate the perm today, sir. Okay. Your prevailing wages itself is taking 4 to 5 months minimum, right? And then you file a perm application. Perm application processing is taking 11 to 12 months these days. Almost 10 to 11 months these days.
అండర్స్టాండ్ అలా కదండి. ఇప్పుడు ఈ 9 months చేసేసి అతను H1 ఫైల్ చేసి వర్క్ చేయించి పెరం ఫైల్ చేస్తాం, వెయిటింగ్ మీన్ టైం అయిపోతే కనుక మళ్ళీ H4 ఫైల్ చేసి వాళ్ళ వైఫ్ దాని
Yeah, atla, sir, that's what I'm saying. If you want, my whole point is, the whole point is him wants to work on H1B continuously. If he doesn't want to work on H1B continuously, then yes, the solution what you said is what we always do with all the employees, you know, and we always do with all the employees the same thing, and that's what we do. But the point here is he wants to come on only on H1B in this country.
No, just he's asking us what is the best option and
so the best
suggestion.
option is this. Best option is this. I mean, my issue is best option is this. I would say that if he's eligible for the cap, let him try for the cap, and then try to come on H4 visa a year. And if he doesn't get selected in the lottery, then he can anyway convert to change of status to H1B for 9 months, right? If he's an H4 year, see if he can find an employer, any employer who can file a perm application, everything for him. And once he files for the change of status, file it in regular processing, because perm application processing will take 4 or 5 months by the time. And then his 9 months starts from the day his H1B starts. So 4 plus 9 months is equal to 13 months. That means he will get automatically 7th year extension based upon that. Because his labor is considered pending for 365 days, or if labor is approved, he can file immediately I-140, and that I-140 is considered pending for 365 days at that time. That is the strategy which I will follow in this situation, because it's not in the US Kabati. If it's in the US, then I would follow what Om Garu said.
Okay.
You know?
Okay.
టైగర్ అది బెస్ట్ అండి. ఎందుకంటే మళ్ళీ స్టాంపింగ్ వెళ్తాయి, H4 స్టాంపింగ్ ఈజీ వచ్చేస్తారు, తర్వాత అడ్జస్ట్మెంట్ స్టార్ట్ చేసుకోవచ్చు.
Exactly.
Thank you. Thanks, Andy. Yeah.
Exactly.
Thank you. Next, Banu garu, we have 5 questions. I want to wrap it up.
Sure.
Rao Srinivas garu here. He came our B1, B2, applied for change of status, which was approved. I received the docs, applied for SSN. My SSN is waiting for 7 weeks. Is there any way we can speed up?
Which office is this one, sir? SSN office? Where is it?
SSN office. Hello, Andy. Hello, Andy. Hello, Om Garu. Thank you, Andy. Banu Garu, thank you. అది SSN ఆఫీస్ వచ్చేసి ఇక్కడ హ్యూస్టన్ లో ఉంది. రాడ్క్లిఫ్ రోడ్ సంథింగ్.
Yeah, I'm seeing some issues in Texas, Andy, with the change of status applications. Okay, you are not the first guy who heard about this. Okay, and go to the SSN office, Andy. Make a fuss over there.
Yeah.
Okay. Tell them that why this is not being processed. How can we continue working over here? My employer wants me to join. I will lose my job and my opportunity. Do you want me to stay illegally in this country? Make a fuss on that officer. This is something seriously going wrong over there with few officers in Houston. This is not the first case I'm hearing in Houston like this. I think you should go there, and you should make a fuss on the local office over there. Go there, sir. Ask them that you need to talk to the supervisor, get the information from them. What is the problem is? And if they say the issue with the USCIS, ask them what is the issue with the USCIS. Ask them to give that in the writing to you. Okay, and talk politely only. You don't have to write L or thing. Talk politely only.
Okay.
That's very important. Okay, stay firm and talk politely. That's all. You know.
Okay.
Yeah. Sir, ping me offline.
Thank you, Andy.
I will.
Thank you, Andy.
Sir, ping me offline. We can discuss more. Okay. Next, Girish garu. Girish garu. His wife came on, spouse came on H4. Can she work without pay as a work teacher and volunteer? Banu garu.
She can.
Someone came on H4. Girish, are you there?
Yeah, Andy, I'm here.
Sir, the volunteering work is entirely different from what actual worker does. As long as that employer, whoever is giving her volunteer work, can differentiate that, then she is fine. Otherwise, it can be considered as a unlawful work.
అదే అంటే ఇప్పుడు టీచర్ వర్క్, ఇప్పుడు టీచర్ జాబ్ ఉంటుందండి. సో ఇప్పుడు ఏదైనా స్కూల్లో
టీచర్స్ కెనాట్ బి వాలంటీర్ కదండి.
ఓకే.
Simple thing is that unless they have a separate designed volunteer program for the teachers in their school and they implement it on a regular basis, they have a complete documentation on that. That's a different thing. There is no volunteer program over here. It's just that, I mean, so that is something which we can talk privately.
Yeah. Girish garu, manam can talk offline. Okay, thank you.
Okay, sure. Yeah, I can reach you.
Okay. Next, Sai Tota garu from New Zealand. Sai Tota garu, there he is New Zealand citizen. What are the options we have to migrate to US permanently?
Not many options. I mean, where was he born makes a difference. If he's born in India, or if he,
I'm here, Andy.
You're here.
Okay.
So where were you born? Where were you born?
I'm born in India, Andy.
What about your spouse, sir?
She's also from India.
Yeah, not many options available to migrate to this country. You have to go through the same route like everybody else on H1B or L1 or O1 or some other work visa to come into this country and then go through the same process with the immigrant visa, either family-based or employment-based, or investor visa, which is an EB5 investor visa. But being a New Zealand citizen, although you may be eligible for the E2 non-immigrant treaty investor visa, that means you can come into the US to do a business as an investor on a non-immigrant visa. That visa will be extended every 2 years as long as you're doing business in the US.
Oh, all right. Okay.
Okay. But that's the non-immigrant visa. It doesn't give you a green card status.
Oh, okay.
Okay. The permanent resident status. That is only the thing. And if you're, I'm very happy to talk to you privately. And if you want to pursue any of these options,
yeah, I would love to, sir. Yeah.
And love to see how we can help you on that. Okay.
Yeah.
And for the E2 investor visa, it doesn't require too much money also. Okay. And we can actually design the program such a way where you can actually do the business and also the business should be manageable for you.
Okay.
Yeah.
Okay.
Perfect.
Next,
There's one more question for me, if you don't mind, sir.
Vijay T.
Sir, Garu ఉన్నానండి. Thanks అండి.
ఒకసారి విజయ్ టీ గారి క్వశ్చన్ అండి, అది మీరేనా?
నేనే సార్, నేనే.
విజయ్ గారు అడగండి.
Okay, thank you so much, Andy. Hello, Sandeep Garu. My name is Vijay Krishna Tippisatti. So I recently got my H4. I mean, I-140 approved, Andy, and even my wife actually also got her H4 extension recently completed, and we have already applied for the extension as well. But unfortunately, we haven't received the EAD card from USCIS yet. I mean, they have emailed us, but somehow we lost it. I mean, it was not in a mailbox. So we have opened a case with the USPS, and they told me like,
I mean, you have to refile I-765, and I don't think you can do anything with this.
Okay, but the problem is I have recently changed my employer. I mean, I'm still in the process of transitioning actually. So,
but it has nothing to do with her applying for EAD, right? Because because as long as she has a valid H4 status, she can apply for EAD.
She's on H4 extension only, but do we need to do anything as well from our side? Like
H4 extension means is her I-94 expired?
Her I-94 is only until February 6th, which was the previous time. I mean, not previous H1B and ఇప్పుడు నాది extension లో ఉన్నాను, అది కూడా extension అయింది February 6th.
I understand, sir. As I said, her status is dependent upon you maintaining valid status and her duly maintaining her status. It has nothing to do with your employer.
Okay, so తనని ఫైల్ చేయాల్సిన అవసరం లేదు కదండి అయితే?
ఎందుకు ఫైల్ చేయాల్సిన అవసరం లేదండి? తన I-94 ఎక్స్పైర్ అవుతుంది, తను ఫైల్ చేయాలి H4 ఎక్స్టెన్షన్.
తన H4 ఎక్స్టెన్షన్ కూడా అయిపోయిందండి, అంటే మొన్నే చేశారు, నాదంతా పాటు చేశారు.
ఫైల్ చేశారు కదా, ఇప్పుడు మీరు మళ్ళీ EADకి మళ్ళీ ఫైల్ చేయండి.
సో ఫ్రెష్ గా మనం EAD వరకు ఫైల్ చేయాలి, కానీ మన H4 ఆల్రెడీ అప్రూవ్ అయిపోయింది కాబట్టి ఫ్రమ్ February 6, 2023 నుంచి 2026 దాకా ఉందండి. సో
కాబట్టి ఓన్లీ H4 EAD ఫైల్ చేయండి మీరు, అంతే.
H4 EAD ఫైల్ చేయాలి అంటే ఇప్పుడు నా కొత్త కంపెనీ వాళ్ళతోనే చేయాలంటే నేను బయట కూడా చేసుకోవచ్చు అండి మా లాయర్ తో?
సార్, ఇట్స్ హర్ అప్లికేషన్, షీ కెన్ అప్లై ఇండివిడ్యువల్లీ హర్సెల్ఫ్.
ఓకే, సో ఫ్రమ్ ద స్క్రాచ్ చేయాలి అంతే కదండి, ఇంకా వేరే
ఆప్షన్ you can discuss offline. Vijay garu, you can ping me 209360 or our WhatsApp.
ఓకే ఓంకార్ గారు మీది ఇప్పుడు నోట్ చేసుకున్నాను, డెఫినెట్గా పింగ్ చేస్తాను. థ్యాంక్ యూ.
నెక్స్ట్ లాస్ట్ క్వశ్చన్ అనుకుంటున్నాను భాను గారు. మా శ్రీనివాస్ రామశెట్టి గారు అవర్ ఇమిగ్రేషన్ కోర్ మెంబర్, ఆయన అడుగుతున్నారు 140 అప్రూవ్ అయింది, మన వైఫ్ కి అప్లై H4EAD అప్లై చేసాము. ఇన్ మీన్ వైల్ ఐ వాంట్ టు చేంజ్ ఎంప్లాయర్, H4EAD is pending, is it okay?
It is okay, sir, as long as, I mean, there are two conditions has to be met, sir. One is if the I-140 has been approved, it is not pending, and it has not been more than and if it is not more than 180 days, then the employer EA should not withdraw that I-140. Okay, and as long as they don't withdraw that I-140, then she'll be eligible to get an H4EAD. If that I-140 approval date, if by the time is changing to another employer, if it surpasses more than 180 days, and even if he withdraws after 180 days, it does not affect her EAD. She can still get an EAD. So answer is yes, she can apply for EAD, but make sure that those two conditions are met. One is the employer, if it's less than 180 days, that employer is not withdrawing that I-140 at least for 180 days upon its approval. Simple thing is that.
Okay, I think we are good, Bhanu garu. I think a lot of questions are answered. Any questions? It's almost 1.5 hours. Thank you, Bhanu garu. Really appreciate. Bhanu garu, can you please summarize how the Atmiya members can reach out to you, email, or phone number, and how they can leverage, what are the different services you provide, and discount for the Atmiya members? Thank you.
Sure. Thank you. Thank you, Garu. And we are completely immigration law firm, and we represent in all types of immigration matters: employment-based immigration, family-based immigration, EB-5 investor visas, employer compliance issues, site visits, FDNS verification compliance issues, 221Gs with the Department of States, or F1 student issues, J1 visas, whatnot, everything. I mean, Department of Labor issues, compliance issues, whatever. I mean, anything that is related to the immigration, we do that in our office. I've been practicing immigration law for more than 19 years now. And I have a vast experience, and by God's blessing and by our clients' blessing, because our clients encouraged, believed in us, trusted in us, and they entrusted upon us the work which we can do for them, being recognized as one of the top attorneys in the country by various organizations, reputed organizations in immigration law, and very thankful for that. And all the credit goes to our clients for trusting us and entrusting upon us the confidence they have on us to handle their immigration matters, and we thrive to continue providing same service, similar attention to detail, and take care of these matters as competently as possible. That's where we are here. To reach us, you all, as I said, during office hours, you can reach to our office through our office number, which is 703-496-7722, or to my cell phone number, which is 319-400-0053. If you call on my cell phone, and if I don't answer you because I can't recognize your number or anything like that, I want you to text me saying that your name and you're from Atmiya and you would like to speak with me. We will make sure that I'll get back to you. I will talk to you and see whatever I can do for you, for your needs and everything. As I said, I don't want to give a number that we're going to give you this discount, that discount, and everything in services, because that is all humbug. Honestly, I believe that. In services, people cannot value it in the beginning unless they look into the case. If anybody lawyers telling they will give you 24% discount, 30% discount, he will just hype the number and then he will give you a discount. I just want to let you know that. I don't want to give you that kind of a false information. But one thing I will tell you is this: for Atmiya members, the charges which I charge, no lawyer can give you services for that charge. That much I promise you.
I can watch you what the kind of personal attention he gives to each and every client and customer is amazing. I don't know how he is able to do that, being a lawyer. Thank you.
This is Sai. Personally, I am telling to everyone, every Atmiya member, Bhanu garu, I am working with him almost 4 years నుంచి ఆయనతో వర్క్ చేస్తున్నాను. He is giving best service to me till now. Yeah, really appreciate that, Bhan Garu. Just I want to add that comment.
Thank you, Sai Garu. Thank you very much, Shundi. I really appreciate it, Sai Garu. Means a lot, Thank you. And,
sorry, Bhanugaru, we cut you. We want to support you.
Yeah, definitely. Definitely, Garu. That's all I would say. I promise you that the pricing which I give you for the Atmiya members, I will bet on that no lawyers will match that pricing when you come to me. That much I can promise you. I don't want to give you any false numbers. We'll give you 25% discount, 30% discount, because I can hype the number and give you 25% discount. Simple thing is that. It doesn't make any sense, right? So that's not the way it should be. What is more important is how much you trust me, how much confidence you have on me, on my knowledge, on my abilities to deliver your case timely, properly, and making you comfortable. That's why you're coming to us. And I promise you that that's what we will do. That's what we thrive for. And if you have any issues, anytime, I'm always there. You can approach me directly. You can tell me directly. I expect that kind of a feedback from you so that I can improve as an attorney and do the better service for you guys. That's all I can tell you. And I'm very, very thankful for that. And as I said, your community has been supporting me a lot, and I'm very, very thankful. Actually made me, I would say that I've been adapted into your community, and
yes.
I feel like I'm one of you all the time, and I'm very, very thankful for that, Andy. Very thankful for that.
Thank you, Bhanugaru. I really appreciate.
Yeah,
it's a lot for us. Thank you.
Thank you, Andy. Yeah.
Thank you.
Thank you all, Andy. Have a wonderful day. Have a wonderful week ahead. And God bless you all, Andy. Thank you, Andy. Bye.
Yeah,
Good night.
yeah.